Well, good afternoon, everybody. I'm Alan Neal, and I'm currently located somewhere on the south coast of England. And as I was just making the point, at least that proves that since Brexit, we haven't been cut off electronically, if nothing else. Let me begin, if I may, by putting on record my own tribute to Marco. It's now 19 years. It's a terribly long time. And there's a very small group of us who have been coming every year since 2002 to celebrate Marco's life and achievements. And the result is the wonderful Marco Biagi institution and the building, but also a live research network, which is the envy of many in the field. There's a tinge of sadness with this because this year we're joining each other at distance, yes, but we're also joining without the presence of Jacques Rougeau, who unfortunately died on the 16th of April last year. And that obviously diminishes even further that small group of core friends of Marco who hold his memory in such high esteem. So we can remember Jacques alongside Marco this afternoon. We have rather a fun afternoon, I think, in front of us. The title is quite an interesting one: Categories and Employment Status, Outdated or Still Useful Interpretative and Regulatory Tools. And the reason I think it's interesting is that we will have a lot of papers, and we've already had a couple this afternoon, putting an interesting slant on developments in work organization and approaches, as you might say, in the developing real world. But I think it's always helpful to remind ourselves about the tools we've been trying to use for a long, long time, and although those have changed, to ask some serious questions about their adequacy and whether they are of any value at all, or if they are of value, whether they need some change. So I think the questions raised are rather significant ones. They're particularly significant for somebody like myself, who comes from a common law tradition, and this is where the lawyer steps in, because we just had a decision in the United Kingdom Supreme Court involving Uber, which probably is as radical as any decision we've had in the last 20 years. And it marks a shift away from a sort of presumed dominance of contractual arrangements, which for a common law country is really, really challenging. So there are all sorts of different challenges, and we'll find some of those in the three presentations that we have today. We have papers, I have to say, from some of the most beautiful cities around Europe, from Milan, from St. Petersburg, and from Kraków. And each of them in their different ways illustrates how difficult it is, first of all, to deconstruct the problems we're facing, and then to come up with some sort of paradigm for analysis. And so after the three papers have been presented, we have my colleague Ralf Rogowski, both of us, of course, located at the University of Warwick, which is not one of the most attractive places in Europe, being located in Coventry. But Ralf has escaped, and he's currently talking to you from Berlin. So there's something to be retrieved there. But Ralf will give an observation about his views on those three papers. And rather than having questions or interventions along the way, I'll try and make sure that we have some time at the end so that perhaps we can have some consolidated and thoughtful interventions in the remaining time after Ralf has offered his preliminary thoughts. So that's the way we intend to go. The first paper is a fascinating 6-country presentation, and it's presented by Pierluigi Digennaro. And without any more ado, let me pass the floor to you, Pierluigi.
Hello, can you hear me? Hello?
Yes, we can hear you, but we can't see you.
God. Hello?
I think Pierluigi is reconnecting. There we are. We're on now.
Okay, now I
can.
Okay. Okay, I can see and I can see you and hear you. It's okay for you? You can hear me? Okay, so
yes.
Let's try to. I will share my presentation. Sorry, but I disconnected in the wrong moment. Okay. Okay, I'm trying to show my presentation. In the meanwhile, I would like to thank the organizers for their willingness and efforts in organizing this conference, notwithstanding the problems we know. Can you now see my presentation?
Yes, we can.
Yes,
okay. Perfect. Okay, so the article I'm going to present today was published last summer on the #1 of the Labor and Law Issue Journal, and it's a fraction of a more complex multi-method and transdisciplinary research project funded by the ERC that is called SHARE. The project targets the sole self-employment and aims at studying how it is measured, classified, and represented in 6 European countries. Those countries are France, Germany, Italy, Slovakia, the Netherlands, and the UK that was still in the EU when the project was designed. So we decided to not abandon UK, even if they abandon us. And so for those who are interested in our work, you can find all the details and the papers already published on the website ercshare.unimi.it. This said, to understand the condition of those who work in a hybrid area, it was necessary, first of all, to provide a study that encompasses the legal systems of all the 6 countries under scrutiny, intending to examine the distinction between work under an employment contract and self-employment. Normally, labor can be framed into 3 statuses, as we know: dependent employment, self-employment, and entrepreneurial activity, with the third one that is in the private and commercial law domain. In the latest 4 decades, many factors have changed how labor has been organized and integrated in the economy, and I recall them for you in the slide, and they range from the end of the vertical integrated firms to social cultural trend that I'm not going deep on this because I have to be quick. And so the aim of the research was to examine the main criteria used by both statutory and case law to identify the 2 concepts and a tertium genus. So the 2 concepts are self-employment and subordinate work, of course, and the tertium genus that some legal systems have embedded to tackle the problem of forms of work that lie halfway between those 2 categories in search for similarities, and as well as to understand how those legal systems deal with the so-called new forms of employment whose nature is debated. What the analyses have revealed that legal systems under scrutiny still shows similarities due to the historical evolution of labor law across Europe, above all in the area of civil law, of the civil law family, so the continental Europe. But broadly speaking, we can say that they recognize the principle of the primacy of facts over the formal acknowledgement of the contract when the relationship between the parties is assessed, that self-employment evolved as a residual category that collects all the workers that do not match the required criteria to be considered employees, that the external direction of someone else's work has served for a long time as the main parameter to detect subordination until it lost the capability to regulate reality. And so many countries many legal systems started to evolve and to confront the economic and social reality, but but not always moving along a homogeneous path. We know that there was a neoliberal wave extensively insufflating flexibility from the 80s of the last century ahead, but also on the other hand, the scope of the application of labor law was extended by means of a mix of sources that I'm going to speak about a little bit now. All the techniques anyhow operate on a specific area of self-employment whose ranks have been enlarged by the enterprise reorganization of production and by the financialization. And a crucial role was played in any country by case law. Courts started to elaborate new criteria to enucleate dependent employment and to attribute a particular case to the general category of subordination. And this happened by means of different technique, the typological technique, or underlying circumstances that could shed light on the existing link with the employer organization, the economic dependence of the self-employed worker. In some cases, what is interesting is that once a stable case law was created on a specific position, legislators decided to issue reforms that amend this jurisprudence. And the latest case is the case of Germany, for example, but it happened also in France, in Italy, and so on. In all 6 countries, in all these 6 countries, there has been an attempt to cope with the issues related to the growing inadequacy of the concept of subordination in ensuring protection when it is understood merely as a power to direct someone else's work. Because, of course, subordination is broader than that, but sometimes it was understood in that way. So in Slovakia, this happened by loosening the original version of the provision that defines the scope of the code itself, triggering the application of labor law, since the first draft of the law was too detailed and demanding, since all the requisites listed by the dependent work definition had to be contemporarily fulfilled in a cumulative manner. In the Netherlands and in France, by providing a presumption of the existence of an employment contract, which in the Netherlands is based on the length of the work performed in favor of the other party, whereas in France is based on the idea that some professions are more likely at risk of being exploited. In some other countries preferred to rely on the concept of economic dependence and consequently crafted a hybrid genus between subordination and self-employment, and this is the case of Germany and UK. In the case of for Italy, in Italy, to select an area on the border between self-employment and subordinate work, the focus is on the need for coordination with the business organization, which creates a stable form of connection between the 2 parties, and this parameter becomes the selective element to which the protection granted by labor law is fastened. According to the analysis conducted, parameters in use in different countries can be connected to a small number of broader categories. They measure the power to direct someone else's work, the degree of integration in the organization of the putative employer, and who bears the business risk or the economic dependence. So those 3 are the external direction, heterodirection, the external organization, heteroorganization, and the business test or economic reality test, depending on the country. The heterodirection test is useful only in traditional cases of subordination, but the problem is that although the business test and the hetero-integration test were developed to move beyond the strict use of the heterodirection test, they never reached the level to be considered a standalone test. Indeed, they are used mostly in a kind of overall judgment that gives the courts a significant level of discretion in evaluating the single concrete case. It's interesting to see that in the United States, the ABC test developed for the first time in Wisconsin in 1935, today is in use in Massachusetts and in California, and is embedded in a bill in both the country. And despite some differences in the wording of the laws, the three conditions of the tests are designed to, in the same way, to detect if the worker is heterodirect, if the worker is integrated in someone else's organization, if he performs work that is outside the usual course of the hiring entity's business, and if the person is engaged in an independent business. So, under this test, another point actually is that, moreover, it is the responsibility of the employer to prove that the worker does not fulfill any of these conditions. And those conditions resemble the three categories discussed above, so they are similar to what in Europe was developed during this time. And
Pierluigi, I'm going to push you into your last minute. Okay.
Okay, so it's enough for me. So to consider this condition as standalone condition, of course, this will trigger easily the application of labor law. I want to just say one more thing, that basically in the paper I tried to suggest to outline a new concept to couple with labor law protection. That is the concept of subjection, because basically what I think is that sometimes subordination is burdened by its the way how sometimes courts or scholars have interpreted it, and so subjection can be a new marker that try to basically describe how the subjection of a work, and that before was made by the means of the bureaucratic structure of the company, today can be done throughout the market. So the subjection is integrated into a structure that is built within external market and does not pertain simply to the internal market of the company as it would have been in the past. And that's all, I think.
Absolutely super. Thank you very much indeed. It's a good example of respecting the time under pressure. Thank you very much indeed, Pierluigi. Okay, let me, without any further ado then, hand over to Mikhail Kharitonov in the gorgeous city of St. Petersburg. Mikhail, I think you have some slides to share with us, so I shall leave everything in your hands. Thank you.
Okay, thank you. Can I start? Okay, I try to share my screen. 1 second. Do you see my screen?
Not yet.
Not yet. And now?
No.
Very strange. 1 second.
Beware, you have Manfred on your shoulder saying in the good old days they didn't use these things. You've got it? Okay, that's perfect.
Okay, thanks a lot. Okay, let's do it. Autonomous employee and independent contractor, bifurcation point. Problem statement. The main problem of autonomy in employment is determining who we are actually dealing with an employee or with an independent contractor. The core of the problem rests in the difference in legal regulation between employees and independent contractors, as a result of which the use of employee labor as a factor of production is more expensive for the employer than the use of independent contractor labor, both in terms of direct costs, financial obligation to this individual and to the state, and in terms of indirect costs, cost caused by restrictions on contractual freedom. The result is a constant competition of armor and spear the courts and the legislator, mainly the courts, I think, are trying to develop as clear a criteria as possible for distinguishing employees from independent contractors, and employers are trying to find weaknesses in this criteria in order to successfully distinguish employees as independent contractors. This problem has been compounded by the development of methods of labor organization, primarily information and communication technologies. These methods allow for more flexible organization of labor activities and autonomy of labor processes. This further blurs the line between employees and independent contractors and makes it difficult to apply traditional criteria for distinguishing these categories. Due to the lack of time, I will not go into detail on why the existing ways to solve this problem are ineffective. The solution to the problem. The problem can be solved by changing the angle of view of this problem. The question of the essential differences between an employee and an independent contractor can be reframed into the question of the differences between an employment contract and civil contract as independent contractual types. If we know what kind of contract is in front of us, labor or civil, we therefore know how to correctly identify the contractor as an employee or as an independent contractor. Since it is a question of distinguishing between contractual types, i.e. legal categories, the identified distinctive feature or set of features must also be legal in nature. This difference between an employment contract and a civil contract can be caused by various economic and psychological reasons, but it must be stated in the language of law. Let us clarify that this does not mean that it is necessary to find a description of the corresponding criterion exclusively in the text of normative acts. No, it will not be named directly in the legislation, but it is derived from the very nature of the relationship under consideration, since an employment contract has a certain set of mutual rights and obligations of two persons exist independently of labor legislation. The attribute or set of attributes that distinguish an employment contract from civil contract must be universal, that is applicable to each disputed situation, without any reservation that are outside the classification criteria. The universality of the distinctive feature implies that an autonomous employee differs from an independent contractor in exactly the same parameters as an ordinary employee. This feature should be independent of the text of written contracts, i.e. it should be based primarily on the actual interaction of the parties and those aspects of it that are difficult to hide or disguise. Unfortunately, due to lack of time, I cannot provide a detailed proof that solves this problem. Sorry. Therefore, I illustrate my finding with the table of the distinction between an employment contract and a civil contract, EC and CC, and formulate the final conclusions.
Mikhail, I think we've lost your slides.
One, sorry. Так, I try to. Так. Sorry. And do you see my slides? Colleagues? Do you see my screen? Okay. Do you hear me?
Yes.
Yes, you hear me. Thank you very much. I'm very afraid that the sound is off. Do you see my screen?
No. Not
No.
this slide, unfortunately.
Forget
Okay.
about the screen.
Okay, I try to do так. Okay.
Yeah.
Now, okay, 1 second. And the next step. And now?
No.
I don't know because I do
Why
everything.
don't you speak? Just speak, tell us.
Okay. Okay, so I repeat, I cannot share my screen and give the table. In the full version of my report, I analyze why in my table intersection give us an employment contract or a civil contract. And because I cannot share my screen, let's move on the final test for distinguishing between an employment contract and a civil contract. The first step. In the first step, it is necessary to find out whether the relationship is payable and contract-based. If these two conditions are not met, it is obvious that we are not dealing with the employment contract. The second step, it is necessary to find out whether the legislator included the situation in question in the number of employment contracts on the basis of a clearly defined and directly specified in the law feature, subject of activity, type of activity, etc., or excluded the situation from this sphere. In the absence of special inclusions exceptions, proceed to the next step. The third step. It is necessary to find out whether the situation is disputable or indisputable. In the sphere of indisputable situation, I currently include those cases when a written agreement between an individual and an individual entrepreneur or organization uses verbatim language from the labor legislation in terms of determining the rights and obligations of the parties. However, here the situation may be different depending on the peculiarities of the legal technique of labor law in a particular state. If the situation is disputable, then it is necessary to proceed to the next step. The fourth step. It is necessary to discover whether a legal relationship involves personal, in the sense not only as a legal, but also as a physical person. Personal performance of obligation to work by an individual who has entered into a contract. Based on 3 points. First points, the formal moment, i.e. by virtue of the formulations written or pronounced by the parties during the conclusion of the contract. 2 points, the essential moment, i.e. when from the nature of a special activity it is obvious that it has to be carried out by a specifically chosen individual rather than just any person qualified to carry out of the work. And third point, the actual moment, i.e. the behavior of the parties in the implementation of the agreement. When stating the absence of personal performance for each of these 3 points, we can state the absence of labor relation. If it is established that the activity of the contractor is personal, then proceed to the next step. The fifth step. It is necessary to find out whether there is a situation of reciprocity of tasks in which the customer is a natural person, massage therapist, individual coach, etc. In the case of an affirmative answer, it is possible to ascertain the existence of the civil relation. If the answer is negative, then proceed to the next step. The sixth step. It is necessary to find out whether the contractor has an obligation to work a certain period of time, regardless of how many tasks he or she will perform during this period and what the specific duration of each will be. If the answer is yes, we can state the existence of labor relation. If the answer is no, then go to the next step. The final step, seventh step. Using my invisible table, it is necessary to define whether we are dealing with the contract on the granting of personal time that can be used in a certain functional way.
We cannot see your slides. We can see your.
You can see my screen in presentation, or no?
Yes.
Yes.
Yes, yes,
Yeah,
we can see the
okay.
screen. Yep.
Yeah, okay. Thank you very much for saying this. Okay, this is my table, and where is the final? Okay, the seventh step. Using the suggested table, it is necessary to define whether we are dealing with the contract on the granting of personal time that can be used in a certain functional way. We must find the intersection of the parameters of method of determining the execution time of tasks and method of determining the number of tasks, and see to which of them the agreement relates. And my final slides. Results of the application of this criteria can be represented as the following scheme. Thus, the employment contract in the diagram is the area of intersection of circles T and I, excluding the white square, and the area of the white circle. Okay, but this is only for illustrated. Okay, thanks a lot. Thank you for your attention.
Well done, Mikhail. Thank you very much indeed for that. And I apologize. I'm afraid my camera appears to have gone dead on me. So I'll speak at you, and then I'll see if I can fix it when we're coming through the next presentation. So thank you very much, Mikhail, for that one. And finally, the last of the three presentations is coming to you from Kraków, from Kinga Piwowarska. Welcome to you. And this time we shan't have any technological problems with slides, Manfred, because she's not going to use any. So you have a friend already. Lovely. Thank you, Kinga. Thank you very much indeed. The floor is yours.
Good afternoon, everyone. Thank you for the opportunity to participate in the conference. My name, as you told, is Kinga Piwowarska. I'm from Poland, from Krakow. I represent Andrzej Frycz, Modrzewski, Kraków University. As you know, the times of the pandemic have shown that not only employers, but all employed on any legal basis need legal protection, including labor protection. The work and salary of the entrepreneurs, independent contractors, and the self-employment should be also protected. Why, whether, when, how, until. This is a lot of questions, but until we answer this basic question, it will not be possible to regulate the legal status of the self-employed workers. The purpose of my speech is to discuss the problem regarding the determination of the legal status of workers who stand in the gray zone. Yes, this is a category commonly considered as self-employed. The analyzed research issue is an actual problem for the legal status of a non-employed or person who are employed in civil law. They are self-employed. So the problem is so-called precarious work. Yes, in Poland, Italy, and any European country. Lack of proper legal protection, in my opinion, for person without the status of the employee cause that unjustifiable differentiation. In my opinion, the terms of axiological values related to the work, for example, dignity, freedom, equality, solidarity, and justice, have proved that the legal status of the working people should not be unjustifiably differentiation. Legal determination of the legal status of self-employed in the context of equal treatment and non-discrimination in employment, wages, the right to the rest, compensation, occupational, safe and health, parenthood, protection, temporary work, also collective labor law and social insurance should be similar or sometimes the same as a worker. I know that it's controversial, but maybe we should think about this. So I propose regulating the status of the people employed in a civil law form, independent contractor, especially self-employed, by creating a universal code code of ethic of employment for all European Union country. I know that this is a big job, but maybe we should think about this. Code will be a soft law, of course. It should be a soft law. European Code of Employment Ethics, something like that. I don't think about the name, but it should be a code of a good practice, and he would be a universal collection of a good practice and interpretive guidelines for all or most of the European country. For example, Italy, Poland, Belgium, Greece, Hungary, German, Slovakia, Spain, because I see that we have some similarity regulation provision in the term of employee, employer, employment relation, civil employment, independent contractor. So in my opinion, code as a guide, some tip, rules of good practice, it should be rules of good practice, would be created for people to be unemployed, to be employed for employers, and for the state bodies, including, for example, National Labor Inspectorate in our country, in Poland, and also for the labor code. The code could be created on the basis of the previous jurisprudence, of course, European Union, Euro country. In my opinion, ordering the situation in this area is mandatory. The more so that it will be facilitating the application of the law, compensate for unjustified existing of society of working people. Yes, the European Code of Employment Ethics could be divided into 3 parts. Employer, so the labor code, no employment, civil law form, and independent contractor, self-employment, and the code should highlight the basis features of the above for this phrase. Each of 3 departments part of this code would contain the features of a given legal relationships, such as the legal basis for the regulation, as well as type and form, scope of organizational and personal subordination, economic risk, personality of work performance, payment, contract notice period, different scope of pension insurance, disability, some accidents, sickness, health insurance, as well as other rights based on the collective protection and interest. What's more, the code would thereof be based on the, in my opinion, International Labour Organization recommendation. It's number 198 regarding employment relationship. The European Code of Employment Ethics, or European Code of Good Employment Practice, I don't know, it's maybe something like this, and thus the demarcation of a given type of employment would make it easier for working people as well as employers or institution bodies qualifying a given type of employment. Easier recognition of rights and obligation. In my opinion, what I can observe in my work on my university for my students, that the people do not know their status. They have no legal awareness. This would help them to understand their situation in the labor market. So the principles contained in the code, which of course would not have the character of universal binding law, as I told, it should be soft law, should be made public information on the internet, on the television, everywhere, because the basic difference between the various types of contracts should be known, especially to a group of people called precarians. So it's my idea. I don't know what you think about this idea, but more information and more details will be in my article. So maybe it will be enough. So thank you for your time.
Absolutely marvelous. Thank you very much indeed. Super. Well, you've had three very varied approaches, particularly to the methodology of looking and constructing a riposte. We're obviously in the land of the regulator, and so there's a fairly conservative lawyer's mindset at work here. But let's hear first of all what Ralf makes of that, and then I'm going to open the floor after Ralf has made his observations. I already have a head of the queue in Manfred, and if anybody else would like to ask something or make a comment, if you'd like to put it on the chat board, I can assemble you and we'll see how much time we can make available, okay? So without more ado, Ralf, who's escaped to Berlin, lucky man, let me pass the floor to you for your observations. Ralf Rogowski, thank you.
Thank you, Ellen. Can you hear me?
Yes, we can.
Good. I had the honor of reading all three papers in preparation for my remarks, and I must say all three contributions are innovative and illuminating, and made me think about the topic of the employment status in a different way. I can identify three different approaches here in the papers, which in my view can complement each other. And these are a comparative, a theoretical or analytical, and a policy-oriented approach. Pierluigi gave us a clear and well-structured paper which compares 6 countries, and I found the clusters, the 3 clusters he came up with, quite convincing, and it's an impressive sort of, empirical work, one can almost say, in identifying the different approaches in these 6 countries. I want to restrict my comments on this paper to 3. First, the choice of countries and clusters is sound and innovative, but I would like to know more. I would have liked to see more discussion if there's any of these clusters, any of these approaches that characterize the clusters are preferable. So he's not really comparing the clusters, and are they all similarly inadequate in his view in dealing with the topic of employment status, or if there's one of these approaches more preferable. Second question is about maybe I stick to 2 questions, 2 comments. This is about the alternative concept that Pierluigi proposes, this subjection. Now I wonder about subjection as the approach as really being something very innovative in comparison to subordination. I couldn't really see the advantage of subjection as a new approach, and I wonder if this paper could benefit from testing the subjection approach by, for example, applying it to a specific case. The Uber case might be an interesting example where he could show us what the subjection approach would argue differently, and what the outcome of applying the subjection approach would be in a case like the Uber case. That would be a suggestion from my side. When it comes to Mikhail's paper, again, a rich paper, very rich paper indeed, that gives us new insights in distinguishing, especially from an analytical perspective, the question of employee or independent contractor. And he also discusses a third category of people, which he really didn't talk much about in his presentation, the dependent contractors, which is an interesting concept. And here I found again something in the paper which Mikhail didn't really talk about in his presentation, but maybe in his response to me he could talk a bit about, which is that he talks about criteria how to measure the dependency of contractors. So the influence of consumers on the contractor, and this actually is a new way of thinking about it, and also become very constructive in identifying employee or independent contractor status. I wonder if the list of criteria Mikhail was presenting to us in assessing the difference between employee and independent contractor, can it be used by judges? I mean, is this really something that is practical in the sense that it can be used in judicial practice? And maybe Mikhail can comment on that. Lastly, Kinga's presentation raises an interesting question. Is there a role of soft law in this whole context of identifying the employment status? Her aim is to present a European Code of Employment Ethics, she calls it, for EU member states, but of course it's a universal code of ethics, in fact, that she's talking about. For those who know my work on reflexive labor law know that I'm very much in favor of using soft law and exploring the possibility of using soft law to improve employment conditions. Now, in which way is ethics a solution? The paper raises the important aspect, which is the company context, and I want to emphasize this, and Kinga might want to work a bit more on the relationship of the soft law approach she advocates with a code at the supranational level of the European Union, and its relationship to company codes of conduct. And actually, the real interesting influence or implementation of such a code she is proposing would be on codes of conducts operating in the company context. And in the end, this approach reminds us that it is the responsibility of employers and management to provide decent working conditions for all that is at stake. And for this, it is really not that important if those who work in companies are employed, self-employed, or something third. Let me finish with that comment.
Super, Ralph. Thank you very much indeed for that. Before I invite our presenters to finish their reflections on your questions and issues and come in, let me invite Manfred Weiss, first of all, to make an observation that he's been dying to do for the last few minutes. Manfred, the floor is yours.
Well, first of all, I would like to agree with you that these three presentations were very, very interesting. But I think the problem is perhaps more difficult. You know, in the first paper in particular, and also in the second, the idea was we might resolve the problem to include the self-employed into the protective scheme by extending the notion of employee as far as possible. This is done nowadays all over in these Uber cases. This is an approach which, in my view, is very limited because you cannot extend a category too far, otherwise it is becoming meaningless. Therefore, I would like to ask what the presenters think of what is the recommendation of the ILO Commission on Future of Work. If you read what they say, they would tell you that it will not help in the future to develop or to change categories. We should stop to classify people and put them in different boxes. What we should do is what they call to develop a guarantee of a universal floor of rights. In other words, we should focus on the umbrella of protection and not on the categories. What do you think of this?
Excellent, thank you, Manfred. There's one for you really to cogitate. You can either look up to the umbrella or look down to the floor of rights. I'm not quite sure which direction we go in that one. Okay. I've not had anybody on the chat suggesting they want to make an intervention. If anybody does, here's your last chance before I pass the floor back to the presenters. Is there anybody else who'd like to contribute? Okay, in that case, let me first of all start with Kinga, because I think I'd be very interested to hear what you have to say about the comments on soft law, possible codes, and put that into the context of what Manfred's talking about, which is the ILO Commission.
I'm talking about soft law.
Yeah, no. But what very much underpins Kinga's presentation is, of course, the recommendation number 198 of the ILO, and you can see those criteria coming in, and that would then enable some thoughts to be given to Ralf's question about how practical, how justiciable even some of these approaches are. So Kinga, would you like to make your comments to start with? The floor is yours if you'd like it.
Yes, thank you. In my opinion, the umbrella and the more important issues that the people who work, everybody person should have the same axiological values, as I told. So it's dignity, it's freedom, equality, solidarity, and justice. And the justice should be on the labor market. So in my opinion, there are the common issue. So yes, I agree with you that maybe it is not possible in Europe have the common code, and I suggest creating something like that in our country, in Poland, because we didn't have this. And yes, I agree that we should also, maybe it will be easier, and we should create this in the company on this floor. So maybe in the future on the next. So thank you.
Excellent, thank you very much for that. Mikhail, I think it leads naturally to you, because the question was put directly in relation to your own criteria. Yes. As to how practical those might be. Ralf was raising that question of what can judges do with it, and obviously you know my background as a judge, so I'm quite interested in hearing what you have to say about that, because at the end of the day the theory has to transport into reality, and one of the obstacles to doing that successfully is quite often the role of the judge or the interpretation of these matters. So can I give the floor to you to make your observations in that area?
Okay, I try to explain. Sorry for my English. I think that my criterion is very practicery, but when we say about decision of court, we must think about two parts. The first part, how determine where is the truth, or in which case is the independent contractor or is the employee how can we determine? And the next part, how we can prove it in the text of our decision. I think my criterion is very good for the first part, because we, in help with this, we can determine in our hand what we see, independent contractors or employee, employment contract or civil contract. And after them, we can prove it with help of then criterion when we know. In practice, we can say about, I try to say it very briefly, my total criteria. In the employment contract, the contractor undertakes to provide the customer with his personal time, when the customer can use in a certain functional way. And with my criteria, we can determine is there or no, in which situation. How we can describe it in the court decision? I don't know. I think I can answer on this question if I try to do this in the each case. I try to do it in for some examples, and yes, I can do it. I can do it. I can do it because I think when if the courts will be, it's unbelievable, but if the courts will be use my criterion, they can use is in the text of decision as a proof, as a legal argument and other. Okay, and I want to say about equal rights and the conception of umbrella. I think there is not very good way. I think this is a bad way, because the logical result of this way will be that the employee will be all individual for each doctors, lawyers, for each man or woman will be employee. But this is not true. Not only in individual employed, self-employment, not as employee in the nature of this relationship. Okay, thank you.
Okay, thank you very much, Mikhail. I think, of course, there we have a very large dispute amongst different approaches to where the preferability might lie. So now it's not the time to open that up. But what I will do, Pierluigi, I'm not going to put you on the spot and demand an answer to Ralph's question on subjection with an example worked with something practical at the moment. But I would be interested to know what you had to say about his first point, about whether you felt any of the approaches which you so clearly set out in the comparative study would be, let's call it, more preferable than others, and if so, why?
Actually, I lost the connection during the. I think I lost the first question that was made. But if I understood well, the question was about the three macro clusters that somehow put together the tests that the courts developed in many countries, and if this can be useful today. I think so. I think that it's useful, and in this way, maybe I also reply to the question about Uber and so on. I think that if we look subordination only as a way to direct someone else work, so the power to direct work, this the subordination is too narrow as a category today for to trigger the labor law standards, and so the protection of worker who are in the same practical situation, disregarding the things that they are formally self-employed or dependent workers. So these three clusters make clear that if the worker somehow belongs to the organization of production and the organization of work of the former client, is actually subjected as well. So he or she needs to be protected by the labor law standards. So if we think at the economical dependency, I mean the things that people are dependent economically speaking, there are already something in place. For example, in Germany, with the third genus that Germany use, or UK. But in my point of view, this way of thinking was a bit of a failure, because actually somehow makes weaker the workers, because some standards that normally are attached to the status of dependent employment are not attached to this tertium genus category. So the only way to protect all the people who need protection is to use one of this category, a big cluster, as a gate to the labor standards, in a way that this one of these tests is enough to create the link that trigger the labor standards, in my point of view. So subjection is a way to say basically that somehow the power to control someone else's work as a means of production, while in the past was made only in the internal market of the company, today is made by throughout the market, the external market. So basically, in the past, when the company were integrated, vertically integrated, of course, the only problem was, I mean, there was no problem because the transaction costs were lower in the internal market of the company and higher outside of the market. But today, you can hire or you can fire a person, or you easily, of course, because of the deregulation, but also you can have control on someone else's work by the market, because the transaction costs are lower in the market today, because platforms basically made it easier to catch all the labor you need.
That of course is the articulation of it, but I think the proposition is a very sharp one, and because of the time, I'm going to ask Ralf, thank you Pierluigi, to come back particularly on that point, but a last word is yours, Ralf. You deserve it.
Okay.
Thank you, Ellen. I do think Pierluigi is right that we need to go beyond the two approaches that have been the dominant approaches so far. The sort of the old subordination approach, which basically focuses on the personal relationship between the employer and the employee, and the ability of the employer to direct the employee in a personal way. And the second, of course, the more common now, the organizational integration test, where the employment status is determined on the position of the worker within the organization, which and what Pierluigi was just focusing on, the new conditions with markets and platforms and all these issues require a new and an enlarged approach. I still wonder if his subjection approach is actually capturing this well, but he's absolutely right that we need to think about a third and new approach.
Superb. Well, look, thank you very much, all of you who've contributed. I have to say, as a common lawyer, I find it intriguing that my own Supreme Court is now talking about purposive approaches of labour law, and is actually quoting Guy Davidov's work in that area in their most recent judgments. So perhaps we're looking at a breakdown of those classic 2 + 1 middle classifications, even from the security of the common law structures we in the island of Europe have been so used to. but we'll see where that takes us. Thank you very much indeed for 3 very stimulating presentations. Ralf, thank you for your efforts in bringing together those observations. Manfred, thank you for your intervention. And the floor, I think, is closed now until
Thank you very much for all your comments.
when there'll be a resumption of the next session. Thank you all very much indeed.
Thank you very much.
Thank you so much.
Thank you. Thank you so much.
Professor Weiss, I didn't want to skip your question. Can you hear me?
Yes, I hear.
And I wanted just to tell you that I would reverse the question. I mean, the point that for me is to understand what does it mean a universal floor of rights? Because my fear is that maybe following this path, it could happen that maybe some workers will lose rights instead of having more workers that at the moment are without rights or with a few rights, bunch of rights, having something more. So that's why I think that enlarging maybe the category of subordination, that then we can also not call subjection, but doesn't matter. But I mean, if we use this subjection path, maybe more workers will have rights. So that's why.
My problem is you cannot extend the notion by all kind of categories to unlimited way, otherwise it's becoming meaningless. Therefore, I think what would be better is to have a floor of rights, and of course this is not something which is minimum. It includes everything. It includes everything.
I hope so. I'm not sure. I'm not that sure.
Yeah. You know, this was a big issue at the debate in the labor conference of the ILO in 2019, when they discussed, well, how far should we go? And unfortunately, they were reluctant because the member states are too much afraid to give too much. And that's why you won't find it anymore, unfortunately, in the centenary declaration of the ILO. But if you read the Commission's report, you know, there it's very clear, you know, and it's actually the idea of my friend Alain Soupiot, who has developed this. And the idea would be that you have a floor of rights, which is everything, you know, except those things which only make sense in an employment relationship. This would only be for those who are in a relationship with an employer, you know, where you need protection against dismissal, for example, which you don't need if you are self-employed who goes here and who goes there and so on. You understand?
Yeah, no, I understand the concerns, and also, I mean, those are basically different ways to reach the same target. The point is how technical this is possible, but yeah, I think there are different ways to reach the same target somehow.
You know, the problem is a different one, and this is one where I have no solution. The problem is when you have a floor of rights for all, then the question is, who is responsible that it will be actually guaranteed? You know, if you have an employer, it's easy. But what are you doing if you are self-employed and there is no employer? You work today for here and tomorrow there and tomorrow there. Then the question is, whom are we making responsible for guaranteeing these rights? And this might be the state, you know, we have to discuss it. This is a real big problem.
Okay, thank you anyhow for your comments, and I didn't want to skip the question. It was just a matter of time.
Very kind of you. No, my pleasure.
Okay. Thank you, my pleasure. Thank you, goodbye.